All right. Anyways, ready to get to your definition?
Um,
I think I've been.
I don't want to.
taken the
I don't want to
challenge.
I don't want to. I'll just throw this out here as a bit of bad faith because I don't like to rely on dictionary definitions, but I just Googled it. I'm curious. So revolution, according to the dictionary, says a forcible overthrow of a government or social order in favor of a new system. Now, maybe the dictionary definition isn't good here, but I know people love their dictionary, so I'll just hang that out there. But okay.
I mean, I don't know. I could also be. I just type in Gandhi's revolution and the AI. The first thing it brings up, Mahatma Gandhi's revolution was a nonviolent civil disobedience movement that aimed to end British colonial rule in India. It was characterized by mass protests, boycotts, and satyagraha, holding firmly to the truth. That's something I believe in as well, against British policies. So, I mean, I don't know. What did people call, Gandhi is considered, quote, India's greatest revolutionary, according to Wikipedia. Nelson Mandela, I think, is called a revolutionary.
Well, careful, because that would much more fit the traditional terms, because they used violence.
Oh, you don't like Mandela, but no, you see what I'm saying.
I didn't like Mandela. I'm just saying you can't compare Mandela to Gandhi. They actually used violence.
Here we go. This will go right there with the Rittenhouse and the assassination clips. All right, you ready to get to your definition?
Sure. Okay. What is the? Hold on, let me find my. Okay, I think I had 4 points for mine. I think one is you have an assemblage of people that are usually united for a common purpose. You've got you're resisting, I guess, like the implementation or the execution of a particular law or interfering with the course of a government proceeding. You are doing this by way of force or intimidation, and it's for like a public purpose, like some kind of like public grievance or whatever, not to like protest like a particular like outcome of a particular court trial or something, I think.
Okay, so let's focus on that fourth part first, because I think it's the most confusing, just so that we can both clear this up. Public purpose, like, so specifically when you were talking about earlier, like the police coming to arrest my uncle, that would not be public purpose, right? That's only privately purposeful to me because I'm just protecting some. That's not something that's, unless the intent of that was to say the police don't have the right to arrest people that X.
Yeah, like if you were to form a militia to try to protect every single murder accuser or accused person of like trying to be arrested, then maybe that could be like for a public purpose. But if it's like a particular criminal conviction of a particular person or a particular arrest, I don't know. I don't think that historically that would have counted as like a public purpose. Okay. I don't think it would count as an insurrection.
Just clearing that up to start, because I know that was, I think, listening to you previously, I think that was one area of difficulty that I didn't really understand. I talked to this hack left-wing lawyer I know, and he was kind of explaining it to me a little. Anyways, so I think in general, the problem with this definition, it is way too broad. Like way too broad, to the fact where I think thousands of things would be considered insurrection. So let's go through these one by one.
Sure, let's go through one particular. Hold on. The way that we're going to do this, okay, because this is important, is we're going to... Wait, hold on. You're going to bring up one, but we need to read and look at the facts of what happened, because that's more important than just a summary of it and then seeing if it fit, because the facts here are very important. So we can go through however many you want for as long as you want, but let me be clear that we're going to look these up. I'm not going to let you give me one sentence and then say, was that an insurrection? And then go to the next thing. We're going to look at the facts of what happened.
Well, I'm not even interested in doing that right now. I thought that was the second part of this debate. When I said we're going to go through them one by one, I meant these 4 things.
Oh, my bad. I thought you meant we were going to go through events one by one. My bad.
No,
forget everything I just said. Go ahead.
Right. So what you're saying is this definition says in order for something to be an insurrection, these 4 criteria must be met.
Yes.
Now, is this necessary or sufficient?
Elements. These are 4 elements, meaning all 4 are necessary.
Okay, so is it sufficient? If all 4 of these elements are made, anything that meets all 4 of these are an insurrection?
There's a name for this kind of incorporation in criminal law. I don't know what it's called, but no, it could be a different thing that's like further down the thing. Like, so for instance, rape has all of the elements in it that is included in like sexual assault, or murder has all of the elements in it generally that are included in like assault. But that doesn't mean that murder is assault or whatever. So like I would say that all four of these are elements of an insurrection, but they might also be like elements of a rebellion, which would be or a revolution, which are further stages of like an insurrection, I would say. So I think I would answer your question like yes, hesitantly, but I don't know where you're going with that, but so I'll say yes, yeah.
Well, but wait a minute, because it seems like those were too contradictory. Because on the first hand, you said it seemed like you were saying, and obviously this isn't a gotcha. If you want to clarify, that's fine. It seemed like what you were saying the first half of that answer is no, there are things that could meet all four of these criteria and they wouldn't be insurrections. But then it seemed in the latter half you were saying, well, no, there are things that could be beyond insurrection that meet all four of these things. So my question is, let me just be as clear as possible. Are there things that could meet all four of these criteria that would not rise to the level of insurrection?
No. It would be things that were at least an insurrection, but they could be beyond. Yes.
So then this is sufficient then. Anything that meets these four criteria. So because you had a huge problem if you said no, obviously, because then this wouldn't be a definition. This would just be some criteria that would be necessary. So, okay. So let's start with the first one. The first one is, I think I have where you got this from, an assemblages of persons. Right? That's number one. I'm getting this from...
An assemblage of people, I think, united for a common purpose. So, like, you put out a notice, like, say, hey, everybody show up to D.C. on January 6th. We're going to go protest the election. People all there for a common purpose.
Okay, that seems fair. I don't think I have much to quibble about that. Okay. So, for example, if we could just hypothetically go through this, like, if you're there to protest fucking your favorite sports team losing, and I'm there to protest Costco raising the price of their hot dog, we'd say, well, that's not really an insurrection, no matter what happens, because there's too many disparate, right?
So I think maybe, but you can have an assemblage of people united for a common purpose that isn't an insurrection, right? Like if you go to a Destiny fan meetup, that's an assemblage of people united for a common purpose, I think, right?
You could do, and let's just clear this up. You could do any one of these four things or a combination thereof. It must be all four to be an insurrection.
Correct.
So you could do 1, 2, and 3, but if it's not 4, it's not an insurrection.
Correct.
Okay, so just want to be clear. So in a situation where and I'm not even going to argue this because I think it's clear that there were enough assembly, even if it wasn't every person there was certainly a group of people that were there January 6th with the intent of we're pissed off and we don't want Biden to be sworn in. So I think that easily meets that criteria. Fair enough. We can move on to point 2. Okay. Second, and what you're reading slightly different. I'm reading directly from, I don't know. This is what Pisco sent me. I thought it was directly from what's the name of the court case?
Are you reading the amicus curiae or whatever?
I think so. So number 2, acting to prevent the execution of one or more federal laws. Okay. Does it have to be federal law? Was your definition federal law?
For me right now, yes, that's what I'm comfortable arguing. It probably could carry over to states. I'm just not sure if you can insurrect against a state.
Well, that seems to be problematic. Why couldn't you insurrect against a state?
Can you commit treason against a state?
Well, I would assume. Why not?
Okay. I'm not prepared to argue that against this. Okay, I don't know if that's possible. I'm not sure.
For example, let's just take a hypothetical like the Chaz zone, right? You don't have to agree that it was an insurrection or anything, but if they take land away from the state or city government, and that government is also part of the United States government, wouldn't that be insurrection against the federal government as well?
I don't know. I wouldn't be prepared. I would have to do more research. Because my definition, hold on, to be clear, because my definition is historically and legally founded, I can't expand beyond what I've researched this definition to encompass. So you could give me hypotheticals where I could imagine maybe it would be. However, it's possible that there are parts of the law or parts of state legal codes or something granted to the states by some amendment or the Constitution that make it so that you actually can't have an insurrection against a state. That's possible. I haven't done that research, yes.
Instead of doing a hypothetical, why don't we go with an argument that you've already made? You made the argument previously that interfering with law enforcement itself is interfering with the executive as they have the ability to, quote, enforce the law. So wouldn't that mean that interfering with law enforcement of a local nature or a state level would also be interfering with the executive idea of enforcement of the law in the first place?
It could be, but law enforcement and the executive is also part of the federal government, right? FBI agents could be showing up to arrest somebody. That could be part of the federal government. If you want to try to expose a flaw or look at something here, I can say, this is the only thing I'm trying to head off, okay? If you want, I'm pretty sure that this definition of insurrection, I think it could evenly apply to a state. But if I say that and then you go, oh, well, actually, in 1872, there were two debates between people in Congress. And I said, well, you can never insurrect against a state. Insurrecting is only to be understood. Then I said, oh, okay, well, never mind. I'm just not, because I haven't done that research for a state insurrection, because January 6th was a federal government, I'm just not aware of that. I don't see personally any reason why this couldn't happen against a state as well, though. That is possible, sure.
I will say that my very limited reading of this, which I'll admit is very limited, seems to suggest actually the opposite. It seems to suggest, particularly the authors that you're using, like Graeber or Bode and Paulson, it seems that they're suggesting that the intent was that they were worried, particularly when they came to the Section 3 of the 14th Amendment, about people in the Civil War that would run for state office or insurrect against their state, like against the government of Tennessee or against the government of North Carolina. And there would be a new, governor there that was adherent to the Union and, the federal government, and they would insurrect against that person. So
Wait. The fear is that another civil war would happen, right?
Well, if you want me to read exactly what Bode and Paulson said, and I know you've cited them previously.
Yes, and I read that entire paper, and I don't remember them saying that they worried about state elections.
Bode and Paulson said, broad interpretation. They argue against the United States should be interpreted broadly to include insurrections against state governments. They point out that the text does not explicitly limit itself to federal insurrections, and that against the United States can be read to include actions against the constitutional order as a whole. Historical context. They provide evidence during the. They provide.
Okay, so it sounds like they're essentially saying what I said earlier, in that, like, I don't know if they've talked about specifically against states, but they're saying that there's no reason why it wouldn't include state governments as well, which is fine. I can agree with that. I'm just not aware of anything in the history. Sure, okay.
I won't read the whole thing. This is the third. I didn't read the whole paper. Being honest with you, I read someone's review of the paper, so it is possible that they're
That's
wrong.
Fine. Wait. Are you reading from the paper right now, or are you reading the review of the paper?
I'm reading review of the paper. So it says, historical context. They provide evidence that during the Reconstruction era, Section 3 was applied to individuals involved in state-level insurrections. So again, I'm willing to have you go through the paper. Like, I started to read some of the paper. I think it's 114 pages.
Wait. Whose paper who? Can you link me what you're reading right now?
Believe it or not, no. I could send you a screen cap. I just took a picture.
Or can you tell me who the author is, or tell me what this paper is?
Yeah, it is The Sweep and Force of Section 3 by William Bode and Michael Stokes Paulson.
Wait, I thought you were reading a review of that paper.
Oh, yeah, I'm reading. So this was, let me see. I don't know. I only screen capped the article I was reading, so I don't know the exact article. So what happened was I talked to Pisco like 2 weeks ago. He sent me articles that he was using and you were using, such as this Graeber testimony in the Coy Griffin hearing, and which linked to, from that testimony, it linked to Bode and Paulson. And so as I was searching Bode and Paulson that evening, was just doing, I don't know what I have, a Safari search.
So you searched for a response to Bode and Paulson debate and then found...
Well, no, I just searched what they thought about state insurrections, and that's what came up. And then I downloaded the paper. I have the paper, but I haven't read it through.
Wait. So are you reading the paper itself, or are you just reading? Because it sounded like you said you were reading like a review or a response to the paper.
It's not a response. It was just like an abstract of the paper.
Okay, wait. Can you tell me what was give me one quote from it so I can find this just in the paper and I can read it real quick.
Sure. Let me see what I have it. Well, shit. The only thing they have quoted. Let me see. Right. These aren't quotes, but it's sort of summary. So they argue that the purpose of Section 3 was to protect the constitutional order at all levels.
Hold on. Protect the...
I'll see if I can find this boat.
Constitutional order.
Sweep and force of Section 3. The sweep, force...
Oh, wait, can you send me even the picture of what you're reading?
Yeah, I could try to do that.
I'll go for
it. Maybe? Yeah. Discord work for you?
Yep.
Okay. I also got some sweet pictures from the water park this weekend. If you
nice. Later.
Well, shit, I don't know if those sent or not. Yeah, okay. There we go. All right. I'll look for this as well. I think I got...
Okay. This isn't a Chat GPT summary, right, Rob?
No, it's not ChatGPT. I think it's Claude.
Okay.
Abstract. Son of a bitch.
Okay. Purpose of the
Do you
amendment.
guys got
What?
Do you guys got like some fucking like these legal articles? How do you get them?
Get
like
what?
everything's always behind a fucking paywall or like.
Oh, there's a website called Sci-Hub. And if you go there and type in like links to papers, usually you can download.
Okay.
Okay, purpose of the amendment. They argue that the purpose of Section 3 is to protect the constitutional order at all levels, not just the federal government. Consistency with other parts of the Constitution. The other parts of the Constitution treat attacks on states as attacks. Okay, this sounds like, I could be totally guessing, it sounds to me like somebody went to ChatGPT and they typed in, does Paulson and Baud's paper apply evenly to the state as it does to the federal government? That's what it sounds like was typed in as a prompt, and it sounds like this is an AI summary in response to that prompt. That doesn't mean that it's wrong. I'm just saying that's what it sounds like. But let me check.
I would say that's probably
Okay, so the sweep enforces Section 3.
I'm
William Baud and
telling
Michael.
you, I got it.
So
Go ahead. Go.
Oh, okay. Paulson actually argued for a broader interpretation of the Section 340 Amendment, including its application to state-level insurrections. Their key arguments include broad interpretation. They argue that against the United States should be interpreted broadly to include insurrections against state governments. Okay, can I find that? So there is that quote, against the United States. Against the United States. Do they have that? Mm-hmm. Hold on, still looking. Okay, what is this? It's the same thing. Okay. Dun, dun, dun. Under the oath. Okay. What is this? Oh, okay. Oh, I have something written about this. Okay. Or, I'm sorry, the Boston Appellate wrote in an annotation here. Of course, mere protest is not okay. So they have a footnote here. What about other disruptive, disorderly, even violent protests during the same year? For instance, the many such events that erupted during the summer of 2020 in the wake of the police killing of George Floyd. So far as we can tell, none of these were covered by Section 3. Of course, mere protest is not insurrection. Some of these protests devolved into riots, but even a riot is not necessarily an insurrection. And even if some of them went further, amounted to, quote, concerted, forcible resistance to the authority of government to execute the laws in at least some significant respect, end quote, and met the definition of insurrection, they would seem to be insurrections against the state governments, not the United States, and thus outside the scope of Section 3. But of course, if there were other insurrections against the United States, Section 3 applies to them all. Okay, this is what I remember reading. Okay, you're gaslighting me.
So so I found the article, page 87, right?
Page 87.
It's talking about the
Wait, when you say article, are you talking about the paper?
Baud and Paulson, yeah, the paper.
And are you talking about 87, hold on.
Page 87, top of page 87.
Okay. I'm here.
I'll read it. Okay. 1975 Act explicitly, this is talking about the 75 Insurrection Act.
Sure, wait. The 1795, yeah, go for it.
1995 Act explicitly recited that it was enacted in part to carry out execution of power to suppress insurrections, but it also applied to repel invasions and enforce federal law. Together, these were the three circumstances where Congress had the power to provide for calling out the militia. Section 1 of the Act allowed the president to call forth the militia whenever the United States was invaded or in imminent danger of invasions from any foreign nation or Indian tribe, as well as upon the request of state authorities in the case of an insurrection in any state against the government thereof. Okay. Section 2 allowed the president to call forth the militia whenever the laws of the United States shall be opposed or the execution there obstructed in any state by combination too powerful, suppressed by the ordinary course of judicial proceedings. Section 2 encompasses insurrections against the United States. And then parentheses. Section 1 specifically deals only with insurrections against a state government. So that seems to at least answer your question as to whether or not there could be insurrections against state governments. Yes, according to the 1795 Insurrection Act. And it provided expressly, which, as you know, these insurrection acts were used as the basis for the 14th Amendment in Section 3.
Sure. So it looks like in 1795, there was an understanding that you can have an insurrection against a state government. That seems to be the case, yeah. But when we're looking at like how it was passed when the amendment was passed, was the 14th Amendment 65? Hold on. Let me check. 14th Amendment. I should know this. 68. Was 1868. So the 14th Amendment was passed about 70 years later. It looks like there was a historical understanding around 1795, which also kind of makes sense because we're really close to the founding of the United States, that you could have insurrections against state governments. I don't know if that same train of thought carried through, but there's at least, I agree, there is a little evidence here that at one point in time you could have an insurrection against the state government. And also, like I said, it might be that today we could think of insurrections against state governments as well if we'd want to as well, sure. I don't know if that would change any part of my argument. I don't know how relevant that is. I'm just uncomfortable biting the bullet on that because I don't know if there's like another law or something like in 1890 that would have explicitly said otherwise, right? But
so then page 91, bottom of it, right before the footnotes, the last paragraph.
Which one?
Starts with finally, page 91.
Page 91, hold on. Okay, final paragraph?
Yes.
You mean this whole last thing? Okay. Finally, several notable invocations of the Insurrection Act occurred during the period of Reconstruction, during the presidency of Ulysses S. Grant. While these events occurred after ratification of the 14th Amendment and thus could not have formed any part of the subjective understanding of the drafters and ratifiers of the meaning of Section 3, they nonetheless deserve mention as roughly contemporaneous evidence of the objective meaning of insurrection as displayed by important usage within a few years of adoption of the 14th Amendment. Briefly summarized, in South Carolina in 1871, Grant invoked the Insurrection Act, as well as suspending habeas corpus, among other actions, to secure order in dealing with the Ku Klux Klan. In Louisiana in 1872, a contested gubernatorial election, which would be by definition a state election, spawned efforts by white supremacists to overthrow the elected pro-Reconstruction Republican government, culminating in the infamous Colfax Massacre of April 13, 1873, in which a white mob attacked and massacred perhaps 150 black citizens who had been defending a courthouse in Colfax, Louisiana, and more broadly, the Reconstruction Republican government. Okay, we can keep reading, but so then it would seem to be the case that, yes, historically, insurrection has been understood as a thing that can happen against a state as well. Sure.
Okay. So, not to belabor the point, that'll come into importance later, but I just think that it's worth clearing up that, and I think that there are other people that I looked at that seem to suggest similarly that insurrection against state government would be tantamount to having you revoked from 14th Amendment Section 3. So, it would qualify as definite. All right, now
hold on. That's a separate argument. It might be true as well. I would have to reread the exact language of Section 3. But what you're saying must make sense though, because I believe local offices people already have been barred based on Section 3. So that should be true. I think that's true. Yes.
Okay. So this is now we're on part 2. So we're agreeing that it wouldn't just be federal. This could also be state. And it would still be termed an insurrection.
Seems to be the case, yes.
Prevent the execution of one or more laws. What does prevent the execution of mean?
My understanding of resisting any law or interfering with the course of government proceeding would mean to resist essentially the United States in their execution or carrying out of a particular law because you're resisting the implementation or execution of that particular law. If you want, I can go to the paper and I can read what they give as definitions or quotations or citations of this.
You can if you want, but would it be fair to say if we're just looking at this in a vacuum now, so this isn't looking at has to be for a public purpose. We're just saying for preventing the execution of a law. So that would literally be anything where I prevent the ability for a police officer to do anything. No. That would be preventing the why not?
Because preventing the execution of a law isn't the same as just I think the idea of preventing the execution of a law or preventing the implementation of a law, resisting the law, is that you don't think that law should exist. So, for instance, if you say we were going to kill every single cop that tried to arrest people for jaywalking, then that would be resisting the that law of jaywalking. But if you were to try to run from a cop who was trying to arrest you for jaywalking, you're not resisting the law of jaywalking. You're not resisting in any way to say that this law shouldn't be a law. You're just trying not to get arrested. That these are fundamentally different things.
I guess I'm going to need you to look up those definitions then that you had of that, because it seems a little tenuous. Like,
So an
you're saying
insurrection
that-
against the United States required resistance to any statute or some public law of the United States. Curtis reminded a grand jury. The law does
Can
not.
I cut you off just
Yeah,
real
go.
quick? I'm not trying to be rude, but that's going to be different because insurrection's requiring all four of these to be met.
Yep.
I'm only talking about Section 2. So when you say an insurrection required, that's not what we're talking about. We're talking about what is the term execution of law mean? To prevent the execution of law. What does that mean?
Yeah, that's what we're reading about right now, right?
But you just started reading a definition. In order for it to be an insurrection,
No,
that's
yeah,
gonna be different.
it's talking about it's talking about what that resistance means. That's what this paragraph is for. Okay, an insurrection against the United States required resistance to any statute or some public law of the United States. Curtis reminded a grand jury, the law does not distinguish between a purpose to prevent the execution of one, several, or all laws. An insurrection could be directed at a legislature as well as at executive officials. William Rawle declared an effort to coerce repeal of a general law to be an overt act of Levying war. Justice Field's opinion in Great House held that any effort to coerce the conduct of government constituted an insurrection. So I don't think that like fighting against police officers trying to do something would necessarily be an insurrection. But if you went to say a courthouse, or they were passing a law, or you were trying to violently protest against legislatures in order to make them change a law, this is resisting a law. It's not just trying not to get arrested for breaking the law.
I'm not trying to be rude, but can you reread the last two sentences or three sentences that you read there in that
insurrection? Yeah, an insurrection could
about coercing.
Yeah, an insurrection could be directed at a legislature as well as at executive officials. William Rawle declared an effort to coerce repeal of a general law to be an overt act of levying war. Justice Field's opinion in Great House held that any effort to coerce the conduct of government constituted an insurrection.
I mean, that's you don't see how broad that is.
You can complain that it's broad, but I mean, this was literally enshrined. Do you acknowledge that the word insurrection was enshrined in an amendment to the Constitution, which is the highest form of governing anything in our entire country? Do you agree with that?
The word is there; they don't define it.
So were they just stupid, or?
Well, no. We'll get to exactly what.
Do you think that they had? Do you think that they had an understanding at the time of what an insurrection was?
You could say that, right? But what we're doing
No, wait. I need a clear answer to that question. We can't go on until you make. No, not you could say that. I'm asking you. Let me ask again. Do you think that they had an idea in mind of what an insurrection was when they enshrined it in the Constitution?
I will answer the question, and then I would like you to answer mine. Fair enough?
Yep.
Yes, I think that they did have an idea of what they thought insurrection was, which is going to actually hurt you because they're looking at insurrection was looking at things like the examples you're giving are post-Civil War, where they were literally worried about literally the Civil War, and at the foundation of our country with things when the federal government was just coming into existence with things like the Whiskey Rebellion, where there were individual states that weren't cohesive and were challenging the authority of the federal government. That's specifically what they were worried about the insurrection, and it even comes more into effect because the people that wrote the 14th Amendment within 10 years basically granted, I don't know what the term is, clemency, or basically waived people that fought for the Civil War that would have been unable to hold these offices under that amendment and said, we forgive you all. Even those people they forgave, right? So it's clear that they had a unique fear of what exactly was going on in the Civil War, which is far different than any of the shit we're seeing today with January 6th or anything.
So that last part hurts you a lot because when they waived clemency, they were reasserting the fact that you did indeed engage in insurrection. That's the point of section... Or no, that would be the point of Section 3 at the end. They said that Congress can pass a law that remedies, right, this injury. They can get rid of the injury, but you did engage in insurrection. That's why Congress has to make an act to forgive you for it.
Well, that's fine. Yeah, no one's arguing that the Civil War wasn't an insurrection, right? But what we're saying is even then, it's clear that that's what they were fearful of, that type of shit. Yep. They weren't looking at things like January 6th.
They were absolutely looking at things like somebody resisting the peaceful transfer of power. I promise you, yes.
So we'll get to that, right? So the part that I wanted you to answer was, it doesn't matter what the foundational idea of what they thought an insurrection was, what your interpretation of that is. What matters is the legal scholars that you're getting that from and what they're saying, right? And what you just read to me was any attempt to coerce the executive or legislator is a levying of war. Any attempt to coerce them to change a law is a levying of war against the United States. Now, I've read this enough to know that actually a lot of these court cases that you're going to claim defined insurrection from like the 1840s and 1850s, they don't actually define the term insurrection. What they do is define the term levying of war. They then go on to later, other court cases say, well, levying of war is like an act of insurrection or rebellion. So given that they use that same language here, any coercion of the government to change a law is an insurrection. That's what
if it involves, read? If it sounds like if it involves like violence and a group of people, yes.
No. Read again what you just read there. That's not what you read. That's not what it said. It said any attempt to coerce the legislative or executive to change a law is a levying of war against the United States.
What did I? Okay, hold on. I'm just Control F. Coerce. That law defined an insurrection as an assemblage resisting law or coercing a legislature by force or violence for a public purpose. This one was persons engaged in insurrection when they knowingly or voluntarily incite or assist an assemblage resisting law or coercing a legislature by force or violence for a public purpose. This isn't what I read before. What did I read? What was it? What did it say? Coerce repeal of a general law. Okay. William Rawls declared an effort to coerce repeal of a general law to be an overt act of levying war. Justice Field's opinion in Greathouse held that any effort to coerce the conduct of government constituted an insurrection. What?
Okay, so define coerce. Coerce, to compel or enforce.
Do you think that if we read this court case, do you think he's just going to say, like, make a strong argument? Like,
well, I don't know. It's evidence.
Okay, wait. We have all the time in the world. Let's read it. United States v. Greathouse. Let's find the source of this quote. When Justice Field said, coerce the conduct of government constituted an insurrection. Okay, Control F.
Can you wait 1 second so I go grab a water? You all right with it?
Yeah, go for it. Let's see if we can figure out what exactly this court case was. The United States v. Greathouse et al. So there were other people involved. This was a circuit court in the Northern District of California. So this would have been, circuit court means it's the first appeal from the district court, unless it was different back then. And these are your federal courts. So this was being tried in federal court. And let me check here. We've got a quote from... If somebody's referred to as a justice, that means they were a Supreme Court judge, I think. So back then, I think that's only for Supreme Court judges. So if he's giving an opinion in this case, it means that he was likely riding circuit back then, meaning that sometimes the Supreme Court justices would drop down to do circuit court decisions because they were bored and had nothing else to do with their time, I guess.
Okay, I'm back. Sorry.
Hi. Okay. Okay, so I'm looking up this case. So this seems to be on the First Court of Appeals, a federal case, United States v. Greathouse et al. Okay, so in reading, I'm just going to read this paragraph to see where this comes from. Okay. Okay. Or should I go up? I'll start here. Wait. The constitutional provision, as you perceive, is divided into two clauses, levying war against the United States and adhering to their enemies, giving them aid and comfort. The term enemies, as used in the second clause, according to its settled meaning at the time the Constitution was adopted, applies only to the subjects of a foreign power in a state of open hostility with us. It does not embrace rebels and insurrection against their own government. An enemy is always the subject of a foreign power who owes no allegiance to our government or country. We may, therefore, omit all consideration to the second clause in the constitutional definition of treason. To convict the defendants, they must be brought within the first clause of the definition. They must be shown to have committed acts which amount to a levying of war against the United States. To constitute a levying of war, there must be an assemblage of persons in force to overthrow the government or to coerce its conduct. The words embrace not only those acts by which war is brought into existence, but also those acts by which war is prosecuted. They levy war, who create or carry on war. The offense is complete whether the force be directed to the entire overthrow of the government throughout the country, or only in certain portions of the country, or to defeat the execution and compel the repeal of one of its public laws. So coerce here, I could keep reading or go back if you want, does not just mean like protest until somebody changes their mind. We're talking about compelling through like force.
Where does it say that? It uses the word force, but what does force mean?
Really, bro? Are we gonna do this? Do you want me to?
Yeah. What I'm saying to you.
Okay,
is,
no,
and this
no,
is
hold
the
on,
way-
wait. I'm gonna read. Now I'm gonna read. I'm gonna back up and I'm gonna read through this, and I'll read longer. And if we can't figure this out, then who knows? Okay. All right. The defendants are indicted for engaging in and giving aid and comfort to the existing rebellion against the government of the United States. The indictment is framed under the second section of the Act of Congress of July 17, 1862, entitled An Act to Suppress Insurrection, to punish treason and rebellion, to seize and confiscate the property of rebels, and for other purposes. And it charges the commission of acts which, in the judgment of the court, amount to treason within the meaning of the Constitution. Treason is the only crime defined by the Constitution. That instrument declares that treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. The clause was borrowed from an ancient English statute enacted in the year 1352 in the reign of Edward I.H., I don't know what the fuck this is, commonly known as the Statute of Treasons. Previous to the passage of that statute, there was great uncertainty as to what constituted treason. Numerous offenses were raised to its grade by arbitrary constructions of the law. The statute was passed to remove this uncertainty and to restrain the power of the crown to oppress the subject by constructions of this character. It comprehends all treason under 7 distinct branches. The framers of our Constitution selected one of these branches and declared that treason against the United States should be restricted to the acts which it designates treason against the United States, in the language adopted, shall consist only in levying war against them or adhering to their enemies, giving them aid and comfort. No other acts can be declared to constitute the offense. Congress can neither extend nor restrict nor define the crime. Its power over the subject is limited to prescribing the punishment. At the time the Constitution was framed, the language incorporated into it from the English statute had received judicial construction and acquired a definite meaning, and that meaning has been generally adopted by the courts of the United States. Thus, Chief Justice Marshall, in commenting upon the term levying war, says, it is a technical term. It is used in a very old statute of that country whose language is our language and whose laws form the substratum of our laws. It is scarcely conceivable that the term was not employed by the framers of our Constitution in the sense which had been affixed to it by those from whom we borrowed it. So far as the meaning of any terms, particularly terms of art, is completely ascertained, those by whom they are employed must be considered as employing them in that ascertained meaning, unless the contrary be proved by the context. So as you're saying, if they obviously believed in a word at the time, but we can see that, then obviously this is what they meant when they put the words in the law. It is therefore reasonable to suppose, unless it be incompatible with other expressions of the Constitution, that the term levying war is used in that instrument in the same sense of which it was understood in England and in this country to have been used in Statute 25 of Edward III, from which it is borrowed. The Constitution's provision, as you perceive, is divided into 2 clauses. This is the one that I read before, where he goes on to say that to constitute a levying of war, there must have been an assemblage of persons in force to overthrow the government or to coerce its conduct. So this sentence, to constitute a levying of war, there must be an assemblage of persons in force, comma, to overthrow the government, comma, or to coerce its conduct. An assemblage of persons in force to coerce its conduct implies force. It doesn't imply it. Explicitly, grammatically means force.
Does it say in force or in force?
In force. To constitute a levying of war, there must be an assemblage of persons in force to overthrow the government, comma, or to coerce its conduct. The words embrace not only those acts by which war is brought into existence, but also those acts by which war is prosecuted. To levy war, to create war, the offense is complete, whether the force be directed to the entire overthrow of the government throughout the country, or only in certain portions of the country, or to defeat the execution and compel the repeal of one of its public laws.
I don't think assemblage in force means that they used force like violence.
No, it could be intimidation as well.
I don't even think it means that. I think the term assemblage of persons in force means a gathering of people for a specific purpose or activity.
No.
Yeah, I think that's...
No.
I'm pretty sure.
I'm not... Nothing that's said in here. This is talking about levying war against the United States. However, we possibly imagine it's just people gathered for a common purpose. You think in the United States of America in the year 18 whatever, we would want to ban assemblage of persons to protest?
Says, let's see.
I can link you this, and I'm on page 8, so you can read it if you want. Here you go. Page 8 of this PDF.
Let's see. No. Just one sec. Again, oh, there we go. Nope. Nope, no good. One sec. I'm just looking for something real quick here.
Sure.
So it's difficult to find an exact definition of persons in force.
Because this is a common, well understood meaning. What we would say is,
so when I type it into Brave, this is what comes up. Define assemblage of force.
Wait, what is
person
Brave?
in force? It's like Google, just less corporate. Based on search results, an assemblage of persons in force refers to a group of individuals gathered together, typically for a specific purpose, event, or activity. This collective gathering can be formal or informal and may involve people with a shared interest, profession, or affiliation. Key aspects: a collection of persons, people, gathered together, assembled, in force. Present,
what is
assembled.
Yeah, can you link me what it's sourcing and we can read?
It's so it linked like dictionary.com and shit, and it doesn't include the terms in force. What it's doing is defining the term in force, right? So then I guess we have to go and see what the term in force is defined as, in regard to an assemblage, which is what makes it difficult. In force, from Collins Dictionary, a law, a rule, or system that is in force, exists, or is being used. When people do something in force, they do it in large numbers. This is from collinsdictionary.com. So in force, they're defining as people doing something in force means in large numbers. Dictionary.com, in force, in full strength, in large numbers, as in demonstrators were out in force. So it seems all the dictionary definitions are saying the term in force when revolving.
Okay, does this sentence make sense? To constitute a levying of war, there must be an assemblage of a large number of people to protest the government. Does that make sense?
Yes.
Wait, you think that somebody
government
would say that if you're going to protest the government with a large number of people, that's an act of levying war against the United States?
Yeah, it's exactly what I'm telling you, how overly broad this definition is. What that's
No, wait, hold on. I'm reading a guy this is a judge that's ruling on this case.
Correct.
You're saying that what he meant to say was, he's saying that, oh yeah, because I'm just reading his words, right? To constitute a levying of war, there must be, and then Rob's definition, an assemblage of a large number of people that are just protesting a law. You think
That's not what it says. It says coercing.
Yeah, but you're trying to say that coerce means just protesting.
Coerce means compelling to change.
Through violence.
Not necessarily.
What do you think it means to compel something? If I say he compelled me to do it, there's some type of, that doesn't mean just asking somebody, right? Even in common parlance, you know that, right?
No, compel could mean a lot of things. For example, I could compel you by saying, I won't vote for you again. Right?
I don't think so.
You could compel
I think that when somebody says a person is compelled, generally that means there's like a requirement. Like there's something like a court compels you to pay. Generally, that's what it generally means. Yes, to compel something. Like it.
I don't disagree. That's what generally means. You're the person that's saying that means violence. It doesn't. It doesn't necessarily mean violence.
Well, in this context, it would mean violence because a protest would never compel you to do anything. You're not compelled by protesters.
It's not true at all. Like, you don't think the Million Man March was designed to compel people to change laws?
No, it was designed to convince them to.
It was certainly designed to compel. You could say, we're not going to vote for you. You could say that we're going to do sit-ins. We're going to disrupt your economic flow. All of those are nonviolent ways to compel change.
Is there?
That's how broad this definition. There's another thing to say about this.
Wait. So then, can you just say? So then, this judge that was writing in this case, these guys are all fucking retarded. Then, right? When they're talking about this, they're saying this guy is saying to constitute a levying of war means to protest the government, and he was an idiot for saying that. You agree with that, right? He was an idiot. This court justice should have never said this, right?
What I'm saying is
no. Wait, don't pivot. Here's the thing.
No, what?
Read this and tell me what he meant by this. I gave it to you. Read it. We can read it together. To constitute a levying of war, there must have been an assemblage of persons in force to overthrow the government or to coerce its conduct. The words embrace not only those acts by which war is brought into existence, but also those acts by which war is prosecuted. They levy war who create or carry on war. The offense is complete whether the force be directed to the entire overthrow of the government throughout the country, or only in certain portions of the country, or to defeat the execution and compel the repeal of one of its public laws. Tell me what he meant there.
What I'm saying, what he meant was that people that come together and compel or try to force or coerce a group of people or legislators to change even one law would be an act of levying war.
Yes, wait, but compel, you
Now,
used force and coerce.
Let me finish, right? The reason that they had such a broad definition at the time is because they're dealing with things surrounding the Civil War. And so it was very serious. They saw the implications of what just happened. Now, this occurs several times throughout history where we could see that laws are very much more strict in certain times, and there's more strict interpretations of what was meant. So the founding fathers, when they're looking at sort of things constituting us fighting as a fledgling country, the Articles of Confederation falling apart, states not agreeing with other states, so they create the Constitution. They were very concerned with the cohesiveness of the United States. So they were going to have a more thorough and expansive definition of what levying war against the United States was. Also true when it came to sort of worries about, and this is particularly using the term treason, because they were worried that there were people sympathetic to the British Crown that were still in the United States. The reason that I'm saying that this definition no longer applies or hasn't applied legally as either the legal standard or the colloquial standard is because if we accept this definition, there would literally be thousands upon thousands of examples in the past 100 years where Section 3 of the 14th Amendment or the seditious conspiracy or the insurrection laws would have been applied or could have been applied. But no one thinks that way.
Okay, let's assume, so I'm not going to grant this, and we're going to come right back to this, but I'm just, to check for consistency, you agree that the Second Amendment should basically be completely repelled, right? Because no part of what a firearm was understood to be at the time or how state militia, no part of that exists today. And back then, when they were writing that amendment, they had no idea that fully automatic, semi-automatic, AR-15s, 60 round, they had no idea that could exist. So none of what they wrote back then is relevant to today, because under the Second Amendment, there would be crazy guns that were made legal, that back then they had musket balls, right? You would agree with that, right?
No, I wouldn't.
Right? How? Why not?
Because what they now, I do think that there are some things that are true of those, such as like nuclear weapons.
No, there's no part of nuclear weapons in part. I'm saying guns, firearms, guns.
Right. What was understood was that actually there were more sophisticated firearms that you might imagine that were around at the time of the Second Amendment, guns that would be considered assault rifles by today's standards, which were legitimate for people to own. But basically the idea
Hold on, what is one example? You're telling me that there is a firearm that an individual could hold where they would pull a trigger and without activating the trigger again, it would fire multiple rounds?
No, that would be automatic. That's not what people consider assault weapons, correct?
Well, I don't know. What do you consider to be an assault weapon?
Well, normally it's one trigger pull, one bullet flies.
That's a semi-automatic weapon. Were there semi-automatic weapons at the time?
Yes.
I thought they were still shooting.
Semi-automatic
weapon means that you pull the trigger one time, and without having to manually cycle a round or without having to manually reload a musket, it'll fire again over and over again. Did these weapons exist at the time?
Yes.
Can you name one?
Gatling gun?
A Gatling gun cannot be held by an individual, no.
But could you own a Gatling gun?
I have no idea. Did anybody own Gatling guns?
Yeah. I think so.
You think so or you know so?
Now, let me be clear.
Hold on. The Gatling gun was invented in 1861. Okay, try again. Wait. The Gatling gun was invented in 1861. Try again.
All right. Let's look this up. First semi-automatic weapon first.
Also, I'm not even sure if the Gatling gun would count as a semi-automatic or automatic rifle because you have to continually cycle in action. You can't just pull a trigger. You're like literally cranking a thing to fire these, I'm pretty sure.
Why wouldn't that be semi-automatic?
Because you have to... semi-automatic means that you just pull a trigger and one trigger action fires a bullet, and you can pull a trigger again and another action fires a bullet. You don't have to manually cycle an action. You don't have to manually reload single shots or whatever. For a Gatling gun, if you're rolling a rotary wheel the entire time, I'm pretty sure this would count as you're doing the actions over and over and over again.
Puckle gun was invented in 1718. It's basically considered the first Gatling gun. It's a revolving firearm. The Puckle gun is tri-mounted, single-barreled flintlock weapon fitted with manually operated revolving cylinder. Puckle advised that its main application is an anti-boarding gun for ships. The barrel is 6 feet. Let's see. Fire mechanisms. After each shot, the crank in the rear are threaded. The shaft that runs through the cylinders turn, allowing the cylinder to be rotated by hand to the next chamber, rotating the cylinder.
I think they made one prototype of this weapon, and it was never produced again. Wait, 2 prototypes. Apparently, during 1740 to 1749, they purchased 2 guns for an unsuccessful expedition in 1722.
Okay. But did the Second Amendment say that you couldn't own those?
I don't even know if an individual
People
could have
don't-
this. This looks like a ship. This is like a ship gun.
What I'm trying to tell you is like that there were more significant guns that existed at the time of the founding of this country than just a flintlock musket. There were more significant guns than that, and they didn't put restrictions saying, well, you could only have certain types of guns. For example, there were cannons. It might not be the same as an AR-15, but certainly in certain contexts could have been far more damaging than even an AR-15.
Do you think a cannon is? Do you think people would have referred to a cannon as a gun back then?
Do you think? I think it would have been an arm to keep and bear arm, correct? That it shouldn't be infringed. Nonetheless, the point you're making is moot because the intention of the Founding Fathers was clearly that the Second Amendment was primarily for stopping tyranny of the government. So
Don't you think these amendments was explicitly for stopping insurrections against the government, like preventing the peaceful transfer of power?
No, it's clear that what this was about was unique situations, as is evidenced by the fact that they were actually giving clemency to people.
They gave clemency through, careful, they gave clemency through the amendment that defines what an insurrection is. So by giving clemency, they agreed that all these people engaged in insurrection. So if you wanted to argue this, you could say, well, Congress could give clemency again, but they're not. They haven't. Congress hasn't granted clemency.
Again, what I'm saying is even they at that point realized, okay, what we had intended this for, right? This was an insurrection based on what we called it. But after 10 years or whatever, 20, whatever it was when they finally gave clemency, or I don't know what the correct term is, if they pardoned or gave clemency, but whatever, when they basically said, okay, it doesn't apply to you anymore. That was literally the worst of the worst. That was people that literally engaged in the Civil War against the United States. And even they were allowed to hold office. And
but hold on, but they had this amendment. They could have repealed this amendment if they thought it was bad. They didn't think it was bad. For purposes of Reconstruction, Congress passed a law that allowed people that had engaged in insurrection to be remedied of the injury that was applied by this constitutional amendment. We could do the same thing today. But they didn't get rid of. They didn't repeal the amendment. They didn't get rid of it.
They didn't repeal it because they still thought that it should apply in situations like the Civil War. They still thought it should apply in
situations where people engage in insurrection.
What you won't be able to. So again, what you'll have to rely on is that you understand how broad this is, and that thousands of things would have met this definition, and they just chose to never charge it for 100 years.
I don't think we're not talking about a charge right now. Right now, we're talking about a constitutional amendment. Okay.
Okay. They chose to never bring to bear the execution of what the amendment suggests for over 100 years.
They did. You literally are bringing up examples of them remedying an injury. This is part of the amendment. This is Section 5 of the 14th Amendment. Is it the Congress? Or I'm sorry, this is in Section 3 actually of that. It's at the end of that Section 3 clause saying that if Congress chooses, they can remedy this injury by passing legislation to grant clemency or whatever. I don't know the exact words. We can look it up. But this is part of the amendment.
That's not what I'm saying. They haven't used Section 3 of the 14th Amendment to keep anyone off a ballot. When's the last time they've done it?
When's the last time someone engaged in insurrection?
According to your definition, thousands of times.
Okay, well, we can go through one if you want and see if it meets all the criteria.
We will. So
Okay.
we're still going through your definition. So
sure. We're never going to. I don't think we're going to agree on it. If you're trying to make the argument that coercion and compelling of a group of people by force, that you think that anybody historically meant that to mean protesters, we're not going to agree on the words of any of this. I don't even think you truly. I don't think you even think that's true. You're giving me like a ridiculous engagement right now.
True. That's not true whatsoever. In fact, we could go and they say, for example, it can be compelling by force to just have large numbers.
When you're gathered there for the purpose of engaging in intimidation, yes.
No. It says that large numbers themselves are intimidating.
Show me. No. Wait. Show me where in the.
Wait. You disagree with that?
Yes. I don't think that they would. I don't think that that's what they consider intimidation.
So just to be clear, if I could find an example, I just want to be clear. If I could find an example from these court cases that you say there's historical that says that engage groups of large people that outnumber police that are there protesting itself, those large numbers, even without weapons, could be an act of intimidation, then you'd be willing to concede that this would mean thousands upon thousands of things have been insurrections in this country.
Okay.
You concede that?
I just want to point out a difference. Number one, that when I allowed you to give me your ahistorical, not researched, and totally unfounded definition of insurrection, at no point was I ever trying to trap you by saying, if you get this one thing, you realize everything's wrong. I said over and over again, you can amend your definition, we can go back and change things. I'm just trying to figure out a thing, okay? Just number one. So I just want to point out the different standard of treatment here. Number one. Number two, you also played a very funny weasel there where you amended your speech in the middle of, if I could find an example where protesters gathered could be seen as intimidation, That's my definition. You can't throw that at me and pretend to fight against me with my own definition. And because I agree with that. A large amount of protesters could be amounting to intimidation. But I'm pretty sure for it to count as intimidation in any sort of sense of like the furtherance of a crime or something like that, you probably need some intent aspect there, or at least some actors for some action that they're engaging in. I don't think just having 10,000 people protesting in an area necessarily counts as intimidation in like a violent sense. I don't believe that's the case. But if you can show me an example right now if you want, and we can go through it, and maybe I'll say, oh, well, maybe this changes my mind then. So if you want, give me an example.
Okay, well, look, I thought I read this in a court case previously, so we'll see if I can find this here. But I just want to be clear, if the case says that large numbers of people themselves can be intimidating, you keep conflating words there. You're saying like intimidation to use violence.
Because
That's
you're saying like intimidating, like what, like spooky or scary? I don't know what that means when you say intimidating.
That's your definition. Your definition says it doesn't need to be force. It could just be intimidation. Correct?
Intimidation of force, meaning a bunch of people can show up who are very rowdy. They might have weapons on them, right? They might be saying things like, we're going to kill you, hang Mike Pence. They're not necessarily engaging in violence, but the intimidation sure is there. Yeah, of course. But just a bunch of people showing up to protest?
This is from the amicus brief. We'll get to point. We haven't finished with point 2 yet. We'll get to point 4. From your author, Graber, right? This is what he says. Point 4. Through the use
Wait. Okay, wait. What page is this? Or wait.
Oh, shit. Again.
No, wait, that's fine. Okay. Okay, you said through the use of violence. Wait, what's the quote?
I don't know what paper this is from. It's I think it's from the amicus on the Coy Griffin case, but it says through the use of violence, force, or intimidation by numbers.
Through the use of violence.
8/16/22, TR 226 1 through 5. So this is from Graber's testimony on 8/16/22. Transcript, page 26, lines 1 through 5. Graber, from the very court trial that you've got this definition from. Graber's the person who created this definition in the Coy Griffin trial. Let me read again what he says here. Ready?
Okay. Can you paste me real quick what you're reading to so I can see it, read it along?
Yeah, yes. And again, this was sent to me by your cohort, Pisco.
Okay.
As what he was using,
That's
which I
fine.
assume he helped you with.
Nope.
So,
To be clear, Pisco did not help me with this. Okay, I read through this amicus briefs on my own, and I read through all of Baud and Paulson's paper on my own, and I read through a couple of these court cases on my own. Pisco has like linked me things to look up, but Pisco did not help me in the preparation for anything. I did all of my prep on stream. I read this whole thing on stream. Everybody watched me do it on stream. Just to be clear.
Okay, I'm being a little tongue in cheek. Pisco's never helped anyone,
That's fine.
so we get that.
Damn.
Did that shit send to you before? Yeah, there you go. Okay.
Okay, hold on. Let me open this so I can read.
Okay.
Okay.
Now, can I read, just so I can read to the audience, section 4, we're not here yet, but just so 4, through the use of violence, force, or intimidation by numbers. Not, you said, it means intimidation of violence. No. It specifically says intimidation by numbers. Which the clear implication here is what he's saying is if 1 million people show up and they're protesting the law, the fact that there are so many people that overwhelm the...
Rob, what do you think intimidation means?
It could mean... It means... Let me think of... Without looking up what I would say intimidation means.
What do you think it means to intimidate?
To scare someone through your presence.
Yeah, and how are you scary through your presence? Is if they think what's going to happen?
But it could be a lot of things.
Probably violence.
Not necessarily, but it does. Let's say that is the case. Let's say I concede that. And it's not that they have to think violence will occur. They could think that if violence did occur, this group is so intimidating. And we know that they are, quote, levying war if they're intimidating and they are trying to get a law changed, trying to challenge the executive on something. So if a mob of 1 million people show up at a 1 million man march and they're saying things like no justice, no peace, and they want significant changes to the way laws are applied, that would by its very nature be intimidation by numbers.
Okay, here, I'm curious.
What
Do you want to read through the Graber case where it brings up intimidation? We can see what they're talking about. Case of Fries. Graber, was this a Supreme Court case or a district court case? Graber. Oh, fuck, it's citing this fucking brief. Okay, see also, e.g., case of Fries. 9F. Okay, I'm looking for case of fries. Okay, this was an 1800. The year is 1800. This is a court case. I think this was a federal case. Correct. It's in the circuit court. So this is in the First Court of Appeals for the District of Pennsylvania, a federal case. Okay. Now I'm looking for intimidation by numbers. Control F. Intimidation. Okay. There are 13 hits in this document for intimidation. Let's see what we have. What can we find? Okay. I'm just going to read sentences around when I find intimidation, okay?
Yeah.
Hold on. Oh, they write long sentences. Holy shit. An act to lay and collect a direct tax within the United States on the 7th day of March in the year of our Lord 1799 in the country, in the county of Northampton in the state, blah, 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 blah. 7th day of March in the, oh my God, in the said state district, to a great number with, to the number of 100 persons and upwards armed and arrayed in a warlike manner, that is to say, with guns, swords, and other warlike weapons, as well offensive and defensive, being then and there unlawfully and traitorously assembled, did traitorously assemble and combine against the said United States, and then and there with force and arms, wickedly and traitorously, and with the wicked and traitorous intention to oppose and prevent, by means of intimidation and violence, the execution of the said laws of the said United States, within the same did array and dispose themselves in a warlike and hostile manner against the said United States, and then and there with force and arms, in pursuance of such their traitorous intention, he, the said John Fries, with the said person, so as aforesaid, traitorously assembled, armed, and arrayed in manner aforesaid, wickedly and traitorously did levy war against the said United States. Okay, that was the first of 13. Maybe they've got...
Can you link me this in Discord so I can
sure thing.
look as
Here
well?
you go.
Thank you.
I was on page 2. I'm just Control F, intimidation. Did wickedly and traitorously assemble against the United States with the avowed intention, by force of arms and intimidation, to prevent the execution of said laws of the United States. Let's go this. In manner aforesaid as I am wickedly and traitorously to prevent by means of force and intimidation the execution of said laws of the United States, by force of intimidation to prevent execution of said laws, by means of force and intimidation to prevent... Oh, okay. Here we go. He said he should be able to prove that John Prize, the prisoner at the bar, did oppose the execution of two laws of the United States to effectuate which he was provided with men who, as well as himself, were armed with guns, swords, and other warlike weapons, which, by their numbers and military appearance, were sufficient to accomplish their purpose, which was not only to intimidate the officers of the government appointed to execute the above laws themselves, but to release from the custody of the Marshal of Pennsylvania a number of persons who were held in prison by the said Marshal, and to prevent him executing process upon others. So this is saying that because they were armed with guns, swords, and other warlike weapons, which by their numbers and military appearance were sufficient to accomplish their purpose, even without engaging in violence. Yes, so that sounds intimidating, but not just because there were a lot of people. It was by numbers and military appearance, and because they were armed with guns, swords, and other warlike weapons.
Okay, so that's part...
Okay, let's keep looking for other intimidation. The endeavor by intimidation expressed, okay. Again, there can be no distinction as to the kind or nature of the law or the particular object for which the law was passed, since all are alike the acts of the legislature who are sent by the people at large to express their will. Force need not be used to manifest the spirit of rebellion, nor is it necessary that the attempts should have been successful to constitute the crime. The endeavor by intimidation to do the act, whether it be accomplished or not, amounts to treason, provided the object of those concerned in the transaction is of a general nature and not applied to a special or private purpose.
Read that again?
Sure, I'll read this whole paragraph. Mr. Rawl then proceeded, under the direction of the court, to state the law. The treason whereof the prisoner was charged was, quote, levying war against the United States, end quote. When he asked, was levying war against the, what he asked was levying war against the United States, he conceived himself authorized upon good authority to say, levying war did not only consist in open, manifest, and avowed rebellion against the government with the design of overthrowing the Constitution, but it may consist in assembling together in numbers and by actual force or by terror, opposing any particular law or laws, Again, there can be no distinction as to the kind or nature of the law or the particular object for which the law was passed, since all are alike the acts of the legislature who is sent by the people at large to express their will. Force need not be used to manifest the spirit of the rebellion, nor is it necessary that the attempts should have been successful to constitute the crime. The endeavor by intimidation to do the act, whether it be accomplished or not, amounts to treason, provided that the object of those concerned in the transaction is of a general nature and not applied to a special or private purpose. In order to effect the object of those embarked in crimes of this high nature, it is well known that various means are necessarily employed. Various acts may be perpetrated to accomplish the main end. They may proceed by the execution of some enormous crimes, as burglary, arson, robbery, or murder, either or all of them. But even if one of those crimes were committed, even if one or all of those crimes were committed, except the purpose should be of a general nature, they may form distinct and heinous offenses, but the perpetrators may not be guilty of treason. A particular friend of the party should have been in custody of the marshal. Okay. So this is basically saying that, by the endeavor, by intimidation.
This isn't necessary. And it talks specifically about a collection of numbers, correct?
Yes, to...
Now I'm looking at this. Go to page 10. Here's the top.
Quote. Okay.
As he
Page 10.
Stated,
wait.
Sure. Page 10
at the top. Okay.
Okay. As he stated before, Mr. Rawls said levying war in the United States against the United States was a crime defined by the Constitution. In relation to the Republican form of government existing...
Wait, hold on. I'm sorry. I can't find where you're at. Wait, you said page 10?
Sorry. Yes. Maybe I'm looking at
I'm sorry. No, wait. You read it in the middle. No, you're good. Go ahead.
Yeah. Levying war in the United States against the United States was a crime defined by the Constitution in relation to the Republican form of government existing among us now. It can only consist in an opposition of the will of society, which we're all members, declared and established by a majority. In short, an opposition to the acts of Congress, in whole or in part, as to prevent their execution, either by collecting numbers, by a display of force, or by exhibiting that degree of intimidation which should operate in either way upon those charged with the execution of law, either in the United States or any part thereof. This is saying specifically, notice the term "or" there, either by collecting numbers, by a display of force, or by exhibiting a degree of intimidation which should operate. So this is Rawls clearly saying that a collection of numbers is enough to generate the term levying of war.
Okay. Let's assume, for sake of the argument, let's say that, let's just ask ourselves this question. Do you think that at this time in the United States of America, do you think that these people are talking about if any number of people gathered to protest a law, that counts as levying war against the United States? You think that's
yes,
what
that is what it seems. That is as broad as what they're suggesting. Now let's go to page...
Wait. In that case, we can't. We're at an impasse. We'll never agree.
Why?
Because you don't exist inside of any kind of like historical understanding or inside of like any kind of legislative or judicial understanding of the history of the United States. You're like on an alternative history for the U.S.
I can't. What I think they're saying, as is quite evidenced, is that they're talking specifically about things such as like Civil War, such as the Whiskey Rebellion, such as governors being overthrown in a massacre of 150 black people by radical white supremacists in the state of whatever state that was, Tennessee,
or by like resisting the peaceful transfer or execution of like the electoral vote. Yeah.
I just want to be clear. What we're doing here is going through the cases of the very definition that you've derived from. We're using your definition and the court cases, and we're going through the exact words that they're saying. The words that you're using to claim that January 6th was an insurrection, that people that support Donald Trump are fucking around and finding out if they happen to get shot.
You don't have to jump all the way to the end of this. I understand.
I understand, but what I'm saying is this is where you derive your definition from.
Yeah, but you're not. The problem is you're reading this. You're like cutting. You're using dictionary definitions and then doing ChatGPT to try to cut out like your hyper-specific definitions instead of reading this as like a reasonably minded person who can contextualize the information again. Like if we read this case, if I read what you just said, as he stated before, Mr. Rawls said, levying war in the United States against the United States was a crime defined by the Constitution. In relation to the Republican form of government existing among us, it could only consist in an opposition to the will of the society of which we are all members, declared and established by a majority. In short, an opposition to the acts of Congress in whole or in part, so as to prevent their execution, either by collecting numbers, by a display of force, or by exhibiting that degree of intimidation which should operate in either way upon those charged with the execution of the law, either throughout the United States or in any part thereof, to procure a repeal or a suspension of the law, by rendering it impracticable to carry such law or laws into effect in the place so opposing or in any other part. This offense he considered to be strictly treason against the United States. It is unfathomable to me that a reasonable human being with an understanding of the English language and any common parlance, or any historical understanding of words, would read this and go, oh yeah, he meant that like protesters could definitely be this if there was enough of them. Absolutely not. No reasonable mind. That is absolutely not what he's saying.
That's exactly what they're saying. We'll continue. Again, like I'm using the actual words from the court case that you're saying. In fact, when you bring up the insurrections, the first two insurrections that people say are Whiskey Rebellion, Fry's Rebellion. This is the court case that it came from.